So now we will talk about legal consideration when it comes to owning real estate. So first and foremost, we look at positives and negatives as it relates to ownership. And of course, market conditions and things of that nature can impact, but we'll stay away from the numbers and just look at some of the sort of the legal concepts. First, on the ownership side, so we need to look at, if we're going to own, what would be the appropriate entity for structuring the ownership entity, and how would the relationship with the actual practice work. Individual or group ownership is another consideration. How would financing be handled? Acquisition and purchase, and the arrangement between the lessor and the lessee. Again, on the medical practice side, this is going to sound a little strange, but you actually, in many ways, would be leasing from yourself, and we'll get into that with a little bit more depth. But that would be sort of some of the concepts that we'll cover when it comes to ownership, and some of the considerations you need to have when it comes to owning the dirt that your practice office would be on. The other option, of course, is leasing, and that would be leasing from a third party. And so some of the considerations there are fraud and abuse, the Stark Law and the Anti-Kickback Statute. We'll cover those, and the negotiation of the lease agreement itself. So as far as owning the dirt, as lovely as that sounds, that's sort of the legal parlance for the ground that the building is on, so we call it the dirt. But for most practices, a separate LLC would be the proper course. In a prior discussion, we talked about the benefits of LLC ownership. So in case you are not listening to the other one, I'll sort of do the short version here, in that there is additional liability protection in Florida for LLCs that are owned by more than one owner. So lawyers in my world tend to use LLCs for real estate ownership for medical practices. Again, this is an entity that is separate from your medical practice entity. With the exception of leasing, which we'll talk about, and some of the fraud and abuse components, this is not an entity, of course, that provides healthcare or anything like that. So as it relates to being, it does not need to be a PLLC, and frankly probably couldn't, but also does not have those healthcare components. Generally speaking, if you're the only owner of the real estate, your operating agreement could be quite simple. But again, meet with your attorney and your accountant to discuss the nuances associated with that. Why would you have a separate LLC? That is the key to this. It separates the liability between the practice entity and the real estate entity. So in other words, and there are two examples up there, you do not want any potential liabilities of the real estate entity to bleed into the practice entity and vice versa. A great example would be, you do not want your real estate to be at risk if there is malpractice committed at the medical practice. You'd like those separated. By the same token, if there is a slip and fall at the practice location, you do not want your medical practice to end up having to pay any amounts on liability for something that was really the responsibility of the entity that owns the practice. That is why we prefer and strongly recommend to essentially all of our clients that the real estate be kept out of the practice entity, that they be in separate entities. Again, you're siloing liability. So next, it would be deciding who will own the real estate entity. So are you going to have a sole owner or multiple owners? Sole owner, again, there's some simplicity when it comes to the operating agreement. You'll get additional protection, certainly if you have an LLC that has multiple owners. The owners of the medical practice need not be the same as those in the real estate entity. That can be complicated, though. I point that out because, again, you can have certain, if we stick just with the physicians in the practice, some practices are set up so only a subset of the physicians own the real estate because they were there first, and they don't offer real estate ownership to newer owners as time goes on. It can create complication, both psychological, some people saying, well, how come I don't get a chance to own in the real estate? And also just from a documentary and operations standpoint, it can create complication. Not terrible in my world, but can just create operational complication as well. But totally doable, not uncommon to have that. It's also not uncommon anymore to just have consistency between the owners of the practice and those who own the real estate. And as I mentioned, the group practices, if they have the same owners, would get extra liability protection as multi-member owners of an LLC. As far as the operations of the entity, it's very, very important that the real estate have its own operations, have its own books, its own operating agreement. It's important that it be a fully functioning separate entity, because you want to be able to, again, show the distinction between the real estate entity and the practice entity to continue to be able to successfully silo that liability. A lawyer that is suing one of these entities is going to be looking for things like no operating agreement, no meetings if your operating agreement requires you to have meetings, or if there is no annual meeting if it's a corporation, things of that nature. You're looking for things that show that this is sort of more of a sham and not a legitimately running company. So it's got to file its own tax returns. Make sure you're paying that annual fee when you get that card from the Division of Corporations in Florida. Be a fully functioning separate entity. The operating agreement is also important. If you have more than one owner, that's going to take some negotiation between the owners. Again, you want to look at things like how are you going to value the ownership. Often in the real estate context, not always, but often in the real estate context, the way an ownership interest is valued is based on the percentage of ownership multiplied times the value of the dirt. So often you will have a valuation done at the time of a buy-in or buyout, and the person will pay their percentage of that amount. Again, as I always recommend, make sure you seek the advice of your accountant and your attorney. The nuances, of course, are important here. So now let's talk about, you've got the entity in place, you've got the operating agreement, everything is ready to operate, and you need to have one more document in place, which of course is the lease. The medical practice would be leasing the space in the building from the entity that the new LLC that owns the real estate. And again, this is goes towards one, you always want that clean relationship to be clear. So it's important for that to continue that liability protection, that you have two separately functioning entities that have an arm's length relationship with each other via a lease, via contract. So it's very important from that regard to continue showing that you've got distinctly operating entities. It's also important if you have a distinction between the owners of the real estate and the owners of the practice, because you want it to be very clear what those lease terms are, because what might be good for goose might not be good for gander. So it's important to have a lease in place that is clear, legitimate, and covers all important terms. Again, your lawyer can assist with that. If you're either just one owner or you have the same owners in the medical practice and in the real estate, an intercompany lease arrangement is what we call it, where it is still a legitimate lease, but the negotiation, so to speak, of it can be far easier because you've got the same owners. So again, you want to have, you might not be as concerned about breaches and things like that, because I don't know about most of you, but most people I know are not in the business of suing themselves, so it makes the lease negotiation process a little bit easier in terms of what you end up getting down on paper. Just some practical considerations when it comes to these things. The one spot that sometimes people wince at a little bit is, remember that you do have to pay, as part of the legitimacy of the relationship, of course, it's also a law, you have to pay sales tax on the rent. That goes for any real estate lease, you have to pay sales tax on the rent. Every once in a while I hear somebody who doesn't want to pay the sales tax and thinks that they would rather, to save the few percent on the lease, they elect to instead just put it all into the same entity. And I'm not aware of anybody having gone through a lawsuit and being happy that they did that on the back end, because again, you're subjecting your real estate to the potential claims of a patient, and of course, just by the same token, you're subjecting your practice to risk of slip and falls and things of that nature. That would really be the responsibility of the real estate entity. So now let's turn to buying the land. Owners must agree in compliance with the terms of the operating agreement. So my point in that regard is that your operating agreement, because again we're going down the road of having an LLC here, the operating agreement is going to state what is required to make decisions, what votes are required. So if you need a majority of the ownership, for example, to agree, or do you need everyone to agree? Usually on bigger ticket things like real estate purchase, you might want everybody to agree. But make sure that whatever the document requires is done, and make sure that's documented properly. Again, your attorney can assist with that, but that's important. You do not want to have issues amongst the owners and have somebody have a claim that the rest of the owners did not comply with the operating agreement. So that's certainly an important component and something to think about right off the bat. Next is the financing. Are you going to finance it first and foremost? Make sure you pick a bank that has experience in the healthcare industry. You'd be surprised, especially when you think about things like surgery centers and certain specialties. When it comes to valuing build-outs and things of that nature, it's important to be able to work with people who understand the industry, who understand how revenue works in the healthcare industry. All these things matter. So you want to try to find a bank that is able to assist and has an understanding of the healthcare context. They also tend to have programs that are favorable to physicians. So that is something that might be a good idea to ask about. I know there are a number of banks out there because most of them reach out to me and want to talk to my clients. So I know they're out there because they reach out with programs. So just can be a helpful consideration. The actual loan documents and construction documents and land acquisition documents also need to be negotiated. It's very important. Don't just, this is a mantra that us lawyers have, don't just sign what's put in front of you. A great example would be architecture ownership of drawings. In the form AIA, the American Institute of Architects, their form contract states that the architect owns the drawings. So you can pay all this money and in many circumstances terminate the agreement, and guess who owns the drawings? Not you. Don't fault them for that. Like anybody, wherever the contract starts, it's usually skewed towards whoever drafted it. That's just kind of the way life works. So it's important, again, that there's the mantra here, to understand what you're signing, and the answer is no if you don't ask, so it's important to try to negotiate these things out. Now, when it comes to loan documents, it is common for banks to say, we're not going to make any modifications to this, just pay your monthly bill and you won't have any problem. That's kind of how this works. That may be true as it relates to some of the loan documents, but again, it's certainly important when it comes to term sheets to make sure that your attorney can assist with helping you understand what's reasonable and also negotiating the deal points on the front end such that they manifest themselves in the loan documents in a way that's more reasonable and appropriate for you. And the same thing goes with construction contracts. There can be provisions, just like any other contract, that are skewed heavily towards the builder, and so you want to know what you're signing and want to have negotiated what is a reasonable contract for the actual construction. Same thing goes again for the acquisition of the actual dirt. Let's turn to leases. The main components I'll focus on here are the fraud and abuse elements, which the anti-kickback statute and the Stark law, as well as certain lease provisions that we'll go over and we'll kind of touch on as well. So the anti-kickback statute is one of sort of the core fraud and abuse laws. There's a federal one that is well known in my world, and also in Florida there is essentially one statute that I call the Patient Brokering Act, that there's also a fee splitting one, but I'm going to mainly rely on the Patient Brokering Act, which is what I would describe as Florida's version of the anti-kickback statute. The good news is, so both of them state that it is illegal to exchange anything of value for a referral. And it's a criminal law. And the state version is also a criminal law. It's in the criminal section of the statutes. Thankfully, both legislatures realized quickly that a blanket prohibition like that would impact many legitimate relationships. For example, leases between physicians or physician groups who refer to each other, who have any kind of referral relationship. We wouldn't be able to refer, let's say you are an OBGYN who is leasing from an ENT and you're good friends with each other and you think each of you is a wonderful physician. How would the tenant be able to pay rent to the landlord if there was a referral relationship there? You'd run afoul of this law. So they realized that, and they developed what are called safe harbors. And so there are a number of safe harbors in the statute, and there's some in regulations. And they govern all sorts of things. Sort of some of the common ones are employment, there's one for independent contractors, and there's one for leases. It is important to meet the elements of a safe harbor. The way the government looks at it, if one meets the elements of a safe harbor, if their transaction or their relationship meets the elements of a safe harbor, it is an indication of what the government will not prosecute. However, failing to meet one element or failing to meet all elements, excuse me, of a safe harbor does not in and of itself mean you have violated the statute. They're evaluated on a case-by-case basis, and we might touch on that a little bit with leases. So the general point here is that you want to make sure that your lease is aligned with the safe harbor for the anti-kickback statute for leases. A few things on penalties. You can see they're significant. The fines are significant. That's a per violation fine. Becomes expensive with just one violation. You can imagine what rent payments would look like, for example, when you have a per violation fine. 5-year prison term per violation. I have seen people go to jail for violating the anti-kickback statute in egregious examples, but the point of it is people do get in trouble for this. On the civil side, you can see also significant amounts of money, and there are times where a violation of the anti-kickback statute is only civil. So that would be, in my world, I'm not a criminal lawyer, in my world more commonly what I would see is a civil one. When I see it on the criminal side, it's because I'm partnered up with a white-collar criminal lawyer. One sub-item I want to touch on in here is the False Claims Act liability that I mentioned. What the government has done over time is the False Claims Act is another one of these fraud and abuse laws, and it says you cannot file a false claim with the government, to the government. The damages include a number of things. One of them is they actually multiply the actual damages to the government times 3. That's a pretty good deal for the government. You've got lots of claims, big money that you can then multiply times 3. Well, if you look at the False Claims Act covers claims that are filed as part of the violation of another law. So a violation of the anti-kickback statute, in addition to the fines that are associated directly with the anti-kickback statute, are also subject to False Claims Act liability because all those claims are tainted by the violation of the anti-kickback statute. So if it's not bad enough to pay all these fines associated with a violation of the law, you can then multiply the amount of claims during that whole time period times 3, and you're also responsible for that. And the government uses that on a consistent basis to just add damages on. So very, very important to make sure that you're compliant here. Of course, that goes for any transaction that you have when these laws are implicated, and this is just a great example of that. So here are the elements of the safe harbor for a lease. 1, the lease agreement is set out in writing and signed by the parties. I should mention that the good news here is that a properly drafted lease in a proper arrangement that involves the correct professionals and the correct parties, most of these are going to be covered by virtue of the fact that you've got your lawyers involved and this has been organized properly. For example, we're all us lawyers are going to make you have a written agreement because we like written agreements because, again, that limits the potential that you're going to end up in court because you've got a clear document expressing the intent of both parties. So the lease agreement set out in writing and signed by both parties. That one's easy to check off. The lease covers all of the premises leased between the parties for the term of the lease and specifies the premises. Same thing, a properly drafted lease is going to have that anyway, so far so good. The term of the lease is at least 1 year. Now you can terminate within that 1 year period if things aren't working out, but the parties are not allowed to enter into a similar or same arrangement during that 1 year period if you terminate. What the government is trying to get people away from is getting into a relationship, seeing that it's more or less lucrative than they thought it was going to be, and retrading that deal within the first year. They want parties to have to make arrangements based on the fact that referrals are not considered as part of their relationship. On that note, these are the ones that are what I would say a little bit less, they're more deal-oriented and compliance-oriented and less directly associated with a proper arrangement anyway. The rent must be set in advance and must be consistent with fair market value and must be commercially reasonable. I package those things together. What they really mean are your fees must be fixed. Again, they cannot take into account the volume or value of referrals between the parties. So 1, you want fair market value. That is sort of circularly defined by the government as the amount that two parties would agree on in an arm's length transaction if referrals were not taken into account. So it's basically, what would two people agree to? And of course, you can get valuations done in the real estate context, and they basically act as support for the fact that parties have agreed to amount this fair market value. Set in advance, of course, it means you don't want it to fluctuate. You are allowed to have set increases. So, typically in commercial leases, you will see what we call an escalator, for example, where, the rent price will go up X% on an annual basis. Those are okay because they're set in advance, as long as, again, they're consistent with fair market value. What you can't do, or what would add significant risk to your arrangement, would be, for example, I'm going to charge you a percentage of the revenue that comes in for the patients I send to you. We'll do a quid pro quo thing. You can't do that. You cannot pay based on referrals. So, key component. So more fun, and those quotes should be far more bold. The Stark Law, which is sort of the other foundational fraud and abuse law in the world of healthcare. This one's a little bit different. The good news is it is only civil, as compared to the anti-kickback statute that is civil and criminal. It's what we call a strict liability statute, meaning that your intent is not relevant. If you violate this, you violate it. There's no, we're going to look at the facts and circumstances the way you did in the anti-kickback statute here. You either violated it or you didn't. You either met an exception or you didn't. So here, there's some similarity in the concept of the law, but there are a few important distinctions. The rule here is that a physician may not make a referral to an entity for the provision of designated health service, which is defined in the statute, for which Medicare payment may be made. And the entity also, of course, cannot present a claim for any of those services. Again, DHS, or designated health services, are outlined in the Stark Law, and there's also a spreadsheet of CPT codes that the CMS puts out, the Medicare program puts out every year, that also lists out additional designated health services, again, that are added to the ones that are set out in the Stark Law. These are just a couple of extra components to it. That last bullet is the important one. This is a prohibition, once again, unless the referral or the financial relationship meets an exception. That's the key. So what you're looking for here is there a designated health service? Is there a financial relationship between the entity and, in our case, the physician? If the answer is yes to those things, then you're looking for an exception. And you'll see in the capital letters, you must meet every element of an exception. An important distinction between the two laws here. Here are the penalties. They're all civil. You'll notice that 3 times amount claimed again in the False Claims Act, same thing. Government looks at any claim associated with a violation as a tainted claim that's considered a false claim that would subject you to 3 times the damages for the amounts of the claims. Thankfully, there are a slew of exceptions here as well. There is one for rental of office space. You'll see a bunch of similarities. That makes life easier on people like me. There are some regulations that are safe harbors and exceptions that are actually a little bit different from each other. So it all needs to go into the soup here when we're negotiating these things. And believe it or not, to make matters even more fun, there are some examples in Florida law that are even different than these, and they actually clash with each other. So it's always fun to have to deal with those. Thankfully, that doesn't really rear its head here as a general matter on the lease side, though. So the exception here, again, some similarity. Agreement is set out in writing, signed by the parties, specifies the premises, so you'll see consistency there. Term of at least a year. We talked about what the parties can do if they terminate within that first year. The space rented or leased does not exceed that which is reasonable. So again, we're talking about just a reasonable standard here. What again they're trying to get away from is, oh, you know, I think what I'm going to do is lease 10,000 square feet from you, physician who is referring patients to me, even though I don't need that much. Again, they want it to be commercially reasonable. And an important one here that we see trouble with sometimes, that we make sure people are doing correctly, is there's an exclusivity requirement. The lessee must be exclusively using the space. A lot of times we work on leases, for example, where only a portion of an office is being leased. There are provisions, so exclusivity is very, very important. There are provisions in the Stark Law that allow for sharing of common spaces, and they talk about how rent is supposed to be handled when common areas are shared. And so just need to make sure that that's done correctly. As you'll see there, charges are permitted as long as it does not exceed the pro rata share of the overall space that's being rented by the lessee. And again, there you'll see the charges over the term have to be set in advance, and they must be consistent with fair market value. So again, you're seeing consistency there. Fair market value and set in advance are always going to be your friend with these laws. That means flat fees. That means set dollar amounts that are fair market value. You do not want to see a lot of fluctuation. That increases risk significantly. And again, when you're dealing with the Stark Law, failure to meet any of these is an automatic violation. So a little bit more discussion on fair market value. I touched on it briefly. The value in the arm's length transaction is what we talked about. So what does general market value mean? That means the price that an asset would bring as the result of bona fide bargaining. So as we talked about, if you're not taking into account the volume or value of referrals between the parties, what would two parties agree to? And when in doubt, and this would go to arrangements beyond just leases, you can consider obtaining a formal valuation. They're often expensive, so I wouldn't suggest them, for example, for employment necessarily. And most know generally what a market is for employment in their area, but you see them often in bigger commercial leases. You see them in practice acquisitions, things of that nature. So always a safe space, so to speak, would be to get a valuation. At least it gives you something that if there's a problem and the government has some questions for you, or anybody else has some questions for you in that regard, you can show them your valuation, because it goes into how that number was derived and it shows how it matches this definition. So now we'll just cover a couple of common lease agreement terms, things to, again, be considering as the lease negotiation process unfolds. And some of these you'll see are sort of universal to contracts in general. Term renewal and termination. So you're going to want to see, again, when does it commence? How is renewal handled? Oftentimes you'll see, for example, and these are not stapled numbers, but for example, you'll see, a 5-year initial term plus 2 5-year renewals. Typically in the commercial lease space, you're generally, especially with physician practices, because of the goodwill associated with your patients knowing where you are, you see interest in a longer term lease because you don't want to find yourself kicked out of the space, for example, if you're the tenant. So it's not uncommon to see terms of 5 years with renewal terms and things of that nature. And of course, same thing goes for termination, another business point for negotiation. And that, of course, all kind of marries together. Just kind of have to decide what the parties want and what they'll agree to. Assignment and subletting. This is an important one for many reasons. I would say the rule of thumb is that typically assignment of the lease, meaning moving the lease to another party, or subletting, meaning you're leasing the space and you let someone else use it, requires the consent of the landlord. That's very common. Typically, of course, the landlord wants to know who's in his or her space, make sure they have a tenant that's going to pay and not going to mess anything up too much. So those things are typically require the consent of the landlord. Now remember, these provisions, even if they're in your what I'll call friendly lease, if you have the same owners in the real estate as you do in the practice, can tend to get negotiated far, far easier when you have that friendly transaction than when you have what I'll call the arm's length or third-party transaction. So assignment and subletting is important. Permitted use, you want to make sure that the language, so in commercial leases, it's very common for there to be a limitation on the permitted use of the space by the tenant. So you want to make it clear that it says that it can be used as a medical practice. You don't want it to be too narrow in that regard. You don't want it to impact your ability to expand. So an important area to pay attention to. Common space, and parking and utility access and the IT capability. Of course, all of these things are important, especially as technology continues to advance in the world of healthcare. You want to make sure that your space can handle your growth, so to speak. Rent, for obvious reasons, that one's important, and let's not forget the compliance component of that. And then also a negotiated area, if it sort of triple net lease, for example, is in the lease context. What about additional charges? How is insurance handled? Who's paying for that? Is that split? Is one party handling it? Same thing goes with the taxes associated with the property. How about additional charges for after-hours use? Things of that nature are commonly addressed in leases as well. Inspection. I have seen a lot of fun in the inspection area. So landlords many times want a relatively short time frame of notice that they have to give. And the tenant may not have too much of an issue with that, but certainly you want at least some reasonable time frame. One, you don't want a landlord traipsing around while you have patients in the office. Two, look at that next bullet. Remember that you have obligations to keep pieces of information confidential and private, so you need to be careful with things that are lying around. As much as everybody tries to make sure that they're HIPAA compliant, I'm sure that office staff and possibly even physicians in the office, if they're not solely on EMRs at this point, they may have patient information lying around, claim forms, anything that might have patient names on it. You need to be careful with those types of things, so you want reasonable notice to make sure that all of that is secured. It should be secured properly regardless of whether your landlord wants to come in, but certainly something to pay attention for. Healthcare compliance is an area where I have seen when things go bad between a landlord and a tenant, and sometimes these things can pop up. But also remember, the fraud and abuse can be applicable if you have a landlord and tenant, both of whom are physicians, and you have that referral relationship, and you've got a landlord and a tenant. So you want to make sure that that is either or both of addressed in general in the relationship, and also with, of course, within the contract. Repair, renovation, and remediation. So, of course, unfortunately, floods happen, fires happen. There are often provisions regarding whether you hit the pause button on the lease if there's substantial damage, what's considered substantial. All of those types of things get negotiated. Build out, whether the landlord is going to pay certain costs related to the build out, what will you be able to take with you as the tenant, what will the landlord keep. All of these things, of course, are important depending on what side of the table you're sitting on. So all things to consider. And we talked a little bit about insurance coverage in terms of who's going to pay for it, but you also want there to be specificity with regard to what insurance is required to cover. So again, theft, fire, water intrusion, other forms of damage, all of those things are negotiable, as well as indemnity. Indemnification is essentially about fairness. It's one party, if the act or non-act of one party causes a damage to the other, then the party whose act or non-act causes the damage agrees to make the non-acting party whole. It's about fairness. If I caused you to lose money, I'm going to agree to make you whole for that. This is the essential way indemnity works. Also an area of negotiation when it comes to leases. And of course, this is not an exhaustive list. Lease negotiations are relatively easy, but of course they can be drawn out. That all depends, like any contract, on the willingness of the parties to work with each other and the reasonableness of both parties.